The Honorable Rodge Gutierrez. You have the floor, sir.
Thank you very much, Mr. Chair. Magandang gabi po sa ating lahat. Mr. Chair, as much as I would want to yield to the Honorable Chairman Fernandez, I fear that we are time limited and
Please do not.
and I will not. I hope that Chairman Dan would understand po, no? Because I'd like to follow up on some of the points raised earlier. Also, likewise, I have questions in mind for our ERC Chair and for former President Matibag. However, I'd like to take advantage of the rare opportunity that we've already had our beloved guests from NGCP before us. Actually, I was keen to ask questions to President Almeida. Unfortunately, he had to go due to another commitment. But I'm surprised to find out po, no, na the president of the SGP, who has spoken more on behalf of NGCP tonight, I think would be more than capable of answering my questions. So, Mr. Chair, I'd like to direct my questions to Attorney Sagayo.
Proceed.
Thank you, Mr. Chair. Mr. Attorney Sagayo, magandang gabi po.
Magandang gabi.
Sir, just a few questions po, no, because what I was driving at in the previous hearing was tungkol sa ating share agreement. Although I agree, national security is one of the primary concerns here, but I think we still have to consider, after all, we are talking about performance of NGCP. This is Legislative Franchise Committee. We have to talk about other provisions of the franchise agreement. And one thing that caught our attention previously was the dispersal of ownership requirement. We were asking the representative of NGCP at the time about what, I believe it was what she knew of yung ating dispersal of ownership dito related po sa SGP, ngunit di niya po may sagot dahil wala daw po siyang personal knowledge doon. So I'd like to ask po, just straight right off the bat, was there a swap agreement po between SGP, brokered SGP in the middle between the owners Henry C. Jr., Robert Cuito Jr., and the holding companies One Taipan and what's the other one? Pacifica 21 Holdings.
Yes, Mr. Chairman, there was a share swap agreement.
Before that, Mr. Sagayo, can you just brief us so that I understand you appear here personally in your capacity as SGP President, but we've mentioned earlier that kayo po ay an officer of NGCP for the longest time, almost since the beginning. Okay. When did you transfer po to SGP?
In 2021 po when it became in 2021, Mr. Chairman.
Okay, so you were in SGP since NGCP had need of SGP as
yes, Mr. Chairman. Yes.
Vehicle by means they were going to comply with the dispersal of ownership requirement. So, at that time po, sir.
Yeah, even before that, Mr. Chairman, anong year yun? Even prior to 2021, Mr. Chairman, I was with the SGP.
So what year po tayo nag-start, sir, sa SGP?
Around 2013, 2012, like that.
2013
yes.
to 2012. And at that time po, SGP was owned by who po?
It was owned by Mr. Henry C. Jr. and Robert Cuito Jr.
Already in 2012 and 2013?
Yes, Mr. Chairman.
Okay po. And so from 2009, you mentioned that you were with NGCP from 2010.
2010, yes,
2010. So
Mr.
only
Chairman.
from 2010 to 2012, kayo po ay nasa NGCP? And then 2013, nasa
yes.
SGP na po kayo? Or concurrently?
Concurrently, yes, Mr.
There's no
yes.
prohibition naman po. You could
No
serve in
prohibition.
SGP and NGCP. That's why you're so knowledgeable po, no?
Hindi
With
naman po,
NGCP.
hindi
I
naman
mean,
po.
you were
As
able... Sir, let's not be humble now. You answered more than President Almeida tonight.
Hindi naman po. Hindi naman po. It's just so happen na but I've been with the NGCP since 2010 and SGP. I'm not sure 2012, something like that, Mr. Chairman.
Sige po. So you're aware po of the history of the attempt of the NGCP to comply with the dispersal of ownership requirements of its franchise.
Correct. Yes, Mr. Chairman.
So, Mr. Chair, at the time, from 2009 to 2019, you had 10 years. NGCP had 10 years to comply with the dispersal of ownership requirement. Yet, it's correct to say that it failed to comply within the 10-year deadline.
Okay, Mr. Chairman. We did attempt rather, Mr. Chairman, to comply with the Section 8 of RA 9511 on the dispersal of ownership requirement of NGCP. There were previous attempts in 2010, but then, no, apologies, Mr. Chairman. Earlier, around 2014, there were attempts, but then, and then, sorry, Mr. Chairman. Okay. There were attempts previously, but then, in the absence of a regulatory reset and with the pending arbitration between NGCP and Transco and PISAM, we believed then that we cannot get the optimal valuation of our shares. So in 2018, we requested or we filed a motion with the ERC requesting for the extension of our compliance with the dispersal requirement of NGCP.
So, Attorney Sagayo, sir, from 2009 to 2018, there was no attempt to comply with Section 8. Mr. Chairman, sorry, maybe direct the question to Attorney Sagayo.
Sagayo.
Perhaps I should repeat my question. Attorney Sagayo, sir?
There's a question.
Yes.
Did you hear the question?
I'm conferring with our finance, Mr. Chairman.
Mr. Chair, my time is not running po, no?
Okay, we will, don't worry. Only on the questions, not on the answers. Attorney, Paul, can you answer the question, the Honorable?
The question is,
I will repeat.
I'm
for
sorry,
you,
I'm
but
sorry.
Of course,
Yes,
of
I'm
course.
sorry.
Po. Yes, sir. From 2009 to 2018, you mentioned po there was an attempt in 2018 when you reached out to the ERC. But from 2009 to 2018, there was no attempt on the part of NGCP to comply with Section 8. No reaching out to the PSE to inquire about how to initiate an IPO. Wala pong pagkuha ng third-party consultant to perhaps prepare your prospectus.
yeah, but as far as I recall, yeah, as far as I recall, Mr. Chairman, that's, well, that's what I know. In 2018, because of, we believe that market conditions is not suitable for public listing as provided for under our franchise, primarily because of the absence of a regulatory reset by the ERC and the pending arbitration between NGCP, PISAM, and Transco, we filed for an extension for us to be able to comply with Section 8 of RA 9511.
Sir, I understand po no, that you filed for that in 2018. I'll repeat my question po, sir. From 2009 to 2018, was there any attempt by NGCP to comply with Section 8? I understand you had an attempt to reach out to the ERC for this reset that you're mentioning in 2018, but in a span of, you had 1 year left for your deadline. Ano po ang ginawa ng NGCP to comply with Section 8 from 2009 to 2018?
I'm trying to, Mr. Chairman, on that question, can we revert to you on that? Because I am trying to recall, it seems that we did try to hire financial consultants, but that's what we got from them, that market condition in the absence of a regulatory reset, you will not get the optimal value of your shares. That's what I recall. Can we get back to the Honorable Committee regarding this question?
I hope you could get back to me ASAP because my whole line of question is premised on that. Well, it will be following from that po, no? But in the meantime, maybe ask.
Maybe
siguro po
you can
from-
do some research. Can you just pass on that question and go
Sige
to
po,
the
I'll
other
try.
questions and we
In the
at
meantime,
end, we
Mr.
go back
Chair,
to that question.
I'll just have an offshoot. And I'd like
Yes.
to ask siguro po si ERC Chair Di Malanta. What is this ERC reset po that Attorney Sagayo is referring to?
Yan po yung, Mr. Chair, yan po yung delayed reset na pinag-uusapan natin kanina na dapat po yung NGCP, dapat po meron siyang allowed na ni ERC na revenues niya from 2011 to 2015, tapos 2016 to 2020. Pero dahil hindi nga po nagawa yung 2016 to 2020, I think yun po yung sinasabi nila na isang dahilan kung bakit hindi daw po sila nakapagpalis. Nilagay po nila yon dun sa, actually dun po sa petition nilang final sa ERC to seek an extension of the period. But in March 2020, the ERC already ruled that that among others, that is not an acceptable reason, and in fact, the ERC in 2020 concluded that NGCP had not been prudent in performing its legal obligations in listing their shares. So, ERC passed upon those reasons naman po, including the arbitration ground, and the ERC said that the pendency of the arbitration case does not justify NGCP's inability to comply with the franchise.
Thank you, Chair De Malanta. Through the Honorable Chairman, would the ERC know if there was an attempt on their part? I understand, to comply with that Section 8, you'd be talking with the PSE. Pero at least, as in, like, bumusi naman lang, or did they inform you of any attempt, except for that motion for extension in 2018?
None as far as the records po are concerned. But in their petition, they did cite that they already engaged consultants, did initial studies. So, yun po yung extent ng preparation.
Did they substantiate those claims? Did they mention years in which that they hired these consultants?
I will need to check, Mr.
Thank you po.
Mr. Chair. Apo.
Baka po, Chair, with both sides trying to find out, we'd get to the answer sooner. Because what you want to find out is if there was any good faith attempt to apply. Because what we were seeing from the records is that from 2009 to 2018, Section 8 was lying dormant. And I believe the whole reason of having a 10-year period is so that they can start right away in opening up the company for public ownership. It's not an easy process, and it's quite surprising na parang since 2018 pa lang. Is it correct, Madam Chair, that they requested for extension twice?
From the records po, and I will yield to my other commissioners because they were the ones present at the time. I think the request to extend was filed 2 months before the expiration of the listing requirement po. So, 2 months na lang po, mag-expire na yung period.
So sinagad po talaga yung timing ng... And who was the commissioner that we may ask po? Siguro, si Ma'am Maceda po ba?
Commissioner Maceda.
Hi. Good evening po, Commissioner Maceda. May we ask po for your input on this matter po?
Yes, Your Honor. The petition was filed by NGCP 2 months prior to January 2020. At the time, ano na po kasi, magte 10 years na, no? So dapat sila nakapag-public offering na. The Commission actually ruled and issued an order with regard to their petition. Practically, the Commission said, no, we cannot provide you any extension. The reasons you cited for seeking an extension are not valid enough because it's been 10 years. You should have been able to do that, no? So, having issued that order, Mr. Chairman, the expectation is they should actually immediately, kasi yun po yung order, to immediately implement the public offering. However, they filed a motion for reconsideration, and the Commission, in its action on the motion for reconsideration the following year, March as well, the following year, the Commission denied the motion for reconsideration and effectively gave them another 6 months because in denying, the Commission said, okay, your motion for reconsideration is denied, but please complete the IPO no later than November of 2021, effectively extending the period within which they can comply. After that, they filed a motion for clarification. But really the decision of the Commission at the time was the Commission denied the MR.
Thank you, Madam Commissioner. Mr. Chair, asking again Attorney Sagayo, is that correct po? Is that, as far as your recollection, it is the same?
Yes, in 2020, it was denied. We filed a motion for reconsideration. We received the order May of 2021 denying our motion for reconsideration and requiring us to finish our compliance with Section 8 of RA 9511 within 6 months. Immediately when we got that, we started with our public listing, with our compliance with Section 8, and we were able to finish it November 10 of 2021. The 6-month period, Mr. Chairman and Honorable Congressman, would have ended November 14 of 2021.
Mr. Chair, I think there's a difference in wording here po, no? The good Representative SGP said that they were given 6 months to comply with Section 8. But Commissioner Maceda mentioned that they were given 6 months to go push through with the IPO. Which is which? Commissioner Maceda, could you please enlighten us?
If I may. NGCP was directed to complete its compliance with the initial public offering.
So IPO, klarong-klaro po,
Opo.
no? Did
Dun
they
po-
proceed with the IPO?
That's correct, Mr. Chairman. IPO, but Attorney Sagayo is now saying that they complied, but they actually undertook a share swap agreement, not an IPO.
Thank you, Commissioner. Mr. Chair, directing now to SGP President. You were ordered to comply with the IPO, yet you opted for a different method. That's what I'm getting from the Commissioner. Is that
That's
correct?
correct, Mr. Chairman and Honorable Congressman Gutierrez. That's correct. Because under the law, we have two modes by which we can comply with the provisions of Section 8, RA 9511. Number one is through an initial public offering of 20% of NGCP. The second mode, Mr. Chairman, is, and this is very clear under the law, if a publicly listed company with the PSE directly or indirectly owns 30% of NGCP, then this is considered as full compliance with the public listing requirement. That is provided for under the law. We opted, of course, initially, Mr. Chairman, we filed for an extension within which we should comply with IPO. But when we received the order of the ERC May of 2021 and giving us only 6 months to comply with the requirement of Section 8 of RA 9511, at that time, Mr. Chairman, it was already the height of the pandemic. Investor roadshows, cornerstone meetings, as advised by our financial advisors, would be very difficult because of travel restrictions, work from home arrangements. So the advice then was for us to resort to the second mode of compliance. And that's what we did. There is SGP, it is a publicly listed requirement. It owns indirectly 30% of NGCP. Actually 60% because Mr. Henry C. and Robert Cuyuto jointly own 60% of NGCP. And under Section 8 of RA 9511, that is full compliance with the public listing requirement.
Mr. Chair, thank you, Attorney Sagayo po, no? I could see that there's a proviso that the listing in the PSE of any company which directly or indirectly owns or controls at least 30% of the outstanding shares of stock of the grantee shall be considered full compliance with the system requirement. But there's a following, in relation to the ERC's ability to extend po, no? It says, in case compliance with this requirement is not reached, the ERC may, upon application of the grantee, as you very well did, and after notice and hearing, allow such reasonable extension of the period within which the grantee should list its shares of stock. So the extension was referring to IPO po. The order of the ERC was referring to an IPO. I don't think, for me personally, I don't know, but for the consideration of this committee, the extension is very clear. It's only referring to IPO. The second mode, if you opted for it within the 10 years, all fine and dandy. But the extension and the order of the ERC was very clear. How do we now reconcile this po?
Yeah, Mr. Chairman, that's why after we received the order of the ERC denying our motion for reconsideration, we filed a motion for clarification. In the motion for clarification, we clearly stated and we informed the ERC of the two modes by which we can comply with the provisions of Section 5 of RA 9511. And we clearly specified there the backdoor listing mentioned in Section 5. And the ERC came up with an order clarifying that since the law allows you backdoor listing, you can opt or you can choose this mode by which you can comply with the requirement of your franchise on public dispersal of ownership. Thank you, Mr. Chairman. There was a ruling of the ERC itself. That's what we did.
I just would like to ask, when was this? Can you give me the date? When was this ruling of the ERC? The ERC ruling, based on Section 3. It was August 20, 2021, Mr. Chairman. 2020.
21.
They ruled that, no? May I ask, when did you take over? 2009?
09. 09.
09.
Yes, Mr. Chairman.
The Section 8 talks about a 10-year from commencement of its operation. Are you still compliant?
We believe we are compliant, Mr.
Even
Chairman,
though
considering
it's over the 10-year?
considering that it was the ERC that granted us the extension, and under our franchise, it is the ERC that can give us that extension. We believe we are compliant. And in fact, Mr. Chairman, the ERC came up with its order on 14 May of 2021, confirming that we have complied with the provisions of Section 5, RA 9511 on public dispersal of ownership. Transco was furnished a copy of that decision. PSAM was furnished a copy of that decision. They never appealed. They never questioned the decision. I believe, Mr. Chairman, that under the doctrine of immutability of judgment, a judgment that has attained finality can never be altered, can never be questioned, much more, it can never be revoked.
Mr.
Thank
Chair?
you, Mr. Chairman.
Thank you very much.
Thank you very much, Attorney Sagayo. But unfortunately, I think this is where we have to disagree. Mr. Chair, I believe that nowhere does it say that compliance will be determined by the ERC. It only mentioned that the ERC will extend. And I think the determination of compliance, as in multiple cases that we've handled here in the committee, falls with us in Congress. And that's why precisely I'm bringing it up now. For this representational law, I don't know if the rest of the committee would agree, I could see a violation here po, at least initially, from my understanding. Kasi nga po, very clear po dito, all that ERC is empowered to do is to, upon application of the grantee and after notice and hearing, allow such reasonable extension. They do not determine po compliance. So I'm not sure about the validity of that motion for clarification po, no? Especially na that was a hard left turn from the direct order to actually enlist in the IPO. So I think that's something that we have to consider moving forward. And even further than that, even further beyond the legalese, assuming, you know, that colorably it was applied with, I don't think the intention of the law was complied with. It was not. Mr. Chair, what was the ownership of NGCP prior to the share swap agreement?
NGCP, prior to the share swap agreement, 40% is owned by SGCC, 30% is owned by Monte Oro, Grid Resources Corporation, and 30% is owned by Kalakahay Power Corporation.
And Monte Oro, Grid Resources Corporation, and Kalakahay Power Corporation, they are juridical persons po, no? And they're owned by who po? Whom?
Monte Oro. One Taipan Holdings Corporation owns Monte Oro Grid Resources Corporation. Pacifica 21 Holdings Incorporated owns 100% Kalakahay Power Corporation.
These are wholly owned subsidiaries po.
Yes, Mr. Chairman. Monte Oro
So-
and Kalakahay Power are 100% subsidiaries of One Taipan Holdings Inc. and Pacifica 21 Holdings Incorporated.
And who owned One Taipan Holdings Inc. and Pacifica 21 Holdings Inc.?
Henry C. Jr., Mr. Chairman.
And the Pacifica 21?
Pacifica 21, Robert Cuyuto Jr. and Alameda Energy Incorporated.
Alameda. And who owns Alameda Energy?
Mr. Almeda should be in a better position. Can we
Namesake. So pagmamayari po nila.
can we defer? Can we have that during the next session? I think.
Okay. See po. So it's a tripartite. You have 100% ownership by Mr. Henry C. You have 60% on the other side, 60% ownership by Robert Cuyuto, 68%, and then the rest by Mr. Almeda. So 60% of NGCP was owned by 3 people before the share swap.
Correct.
And supposedly, Section 8 is dispersal of ownership to make it public.
Correct.
What was the ownership of beneficial owners ng NGCP after the share swap?
after the share swap, Mr. Chairman, we have here SGP.
Is it correct, Mr. Chair? SGP was owned 49.93% by Henry C. Jr. and 49.81% by Robert Coyuto Jr.
No, prior.
Right after
No.
the share swap.
Right, that's correct. Yes, after the share swap. Yes, Mr.
So
Chairman.
in your supposed compliance with public ownership, it maintained the ownership of these two people.
Yes, Mr. Chairman, if I may, after the share swap, there was a follow-on offering. Magkano yung follow-on offering natin? We issued shares. Yes. Additional 22.12% to be issued to the public. And this was after the follow-on offering, Mr. Chairman. 22.12 of SGP, 22.12% of SGP is now owned by the public.
And this is the SGP is owned by the public 20%. And
That's
SGP
correct.
owns how much of NGCP?
Effectively, it's 60%. SGP owns 67% One Taipan, 100% Monte Oro, then 30 plus 1 of NGCP. Yeah.
So
Okay. Yeah. Okay.
20% of 60%, I apologize, I'm bad at math. Magkano po yan?
Yes. Total, Mr. Chairman, total SGP ownership in NGCP is 45.73%.
How is that, sir? I apologize. I thought it's 20% of SGP is owned by the public, and then SGP only owns, through three
okay.
layers of ownership,
Yes.
60% of NGCP. So 20% of 60%, sir, is...
We're referring to economic interest. Mr. Chairman, I'm also bad at math. I'm really sorry. Can I turn this over to the corporate
A
secretary?
sickness of us lawyers po, no?
So, as a guide, so the total SGP direct ownership in NGCP is 9.24% because there's also, SGP also owns preferred shares in NGCP, so that's 9.24. Direct ownership of SGP in NGCP through preferred shares. And then the total SGP indirect ownership in NGCP is 36.5%. It is computed through One Taipan, which owns 67% of Monte Oro, which in turn owns 27.23% of NGCP. So that's 18.24, and the same percentage is also for the Pacifica 21 and Calaca, 18.24. So the total direct and indirect ownership is 45.73%.
45.73% owned by SGP.
Correct.
And
Direct
how
and
much of
indirect.
that is owned by the public?
Okay. So if we do, there are 5 components, no, to get to the,
Mr. Chair, isn't it much simpler to disperse ownership by listing the shares of NGCP instead of all of this corporate gymnastics? The layering is what makes it so hard, Mr. Chair, and you, I'm sure, as your job as corporate secretary, I think this was intentional. Mr. Chair, the point of Section 8 is encourage accountability and transparency to the public by allowing them to participate in the economic fruits of their investment and also in ownership and control. Mr. Chair, the follow-on offering, this was preferred shares po, no?
the follow-on offering is common shares,
Common
in
shares
SGP.
in NGCP. But SGP's direct ownership that was offered by NGCP, 9% was preferred.
Correct.
Does preferred have ownership? Does
Yes.
preferred have voting rights?
Yes. Non-voting.
Non-voting rights. And in fact, what makes preferred shares so special po compared to common shares?
Well, in this case, it's special because it has priority as to dividends. It has, yeah. And I think that was the storyline of the FOO, was that the funds that you raised from the public, it will be reinvested into NGCP
Mr. Chair, apologies. I'll just cut really quick po, no? You mentioned preference over dividends. But under your articles of incorporation, nakalagay po dito na non-voting preferred shares shall not be entitled to any preference over the common shares in terms of dividends and other economic rights. In this specific case, I hope we talk
Yes,
particularly
correct.
about this. So, wala na pong voting, wala rin preference over dividends. What makes your non-voting shares, what makes your non-voting preferred shares so special?
I have the features here. If you could give me a few minutes.
In
I'll
relation
put
po
it-
at least to the two factors, economic fruits and ownership and control. If you could please give us the salient points.
Yes, just give me a few minutes.
Mr. Chair, while waiting po, no, I just want to share that that's the problem po siguro that we saw. The SGP, through multiple layers, made it very hard for the public to participate in ownership of NGCP. Aside from that, by making it appear that SGP has direct ownership, they did it through preferred, non-voting preferred shares, which don't even have preference in dividends. It seems to be a lot of corporate gymnastics to maintain control for the select few. And that's why I think even if there's colorable compliance with the Section 8 in terms of whether it was IPO or through the second mode, which is what they did through the listing of a company for 30%, the intent of the law was not achieved. They went through extra measures to make sure that our public cannot participate, cannot benefit. And all of this was handed to them on a silver platter. This is a natural monopoly. I'm sorry, Mr. Chair, just to manifest po, no, we've handled a lot of franchises in this committee. But most of the time, we're talking of media, we're talking about distribution utilities. They're a dime a dozen. But this one is this is the only transmission company that we have in this country. Yet this is what we're dealing with. Yes, I believe we're ready na po
Mr.
sila.
Chairman, please, for purposes of compliance with Section 5, RA 9511, dispersal of ownership, actually, we do not need to issue that preferred shares. We issued those preferred shares as a vehicle by which we will funnel the proceeds of the FOO from SGP directly to NGCP. Because there were allegations that the shareholders might pocket the proceeds of the FOO in the amount of 12 billion pesos. We assured the public that this will go straight to NGCP for its CAPEX projects. That's why we issued those preferred shares. But for purposes, Mr. Chairman, of complying with RA, with section, with the public dispersal of public ownership, it's not necessary.
Well, Mr. Chair, that's my point. We're going through all these legalese. Let's just cut the discussion short. How much of the public, how much of NGCP is publicly owned? I don't think it's 20%. And that's the very point that I'm driving at, po, no? And even worse, Mr. Chair, I understand we'll go through that, po, no? And I'd like to go more into the yung board meeting situation that we were talking about earlier. Mr. Sagayo, you mentioned you're a director ever since, po, no?
2010.
2010,
Miss-
which is most of it, po, no? I pioneer. So the board has always been composed of 10 seats, tama po ba?
Tama po.
And it has always been composed of 4 Chinese national board directors.
Correct.
Yet, how much percent po is owned currently by the state grid? 36%?
Common shares, actually it's 40%, Mr. Chairman.
40% pa rin.
Yes, 40%, common shares.
Because this is what happened when we added the preferred shares po siguro, no? So and the preferred shares don't count.
No, no.
Okay, so that's why we have the 40%.
Yes,
and the
40%. Yes.
And generally, when we have board meetings, the quorum would be 50% plus 1.
Correct, Mr. Chairman.
Is that the case with NGCP?
Yes, Mr. Chairman, yes.
Mr. Chair, according to your bylaws on Section 7, 7 directors shall constitute a quorum.
Correct, Mr. Chairman.
Mr. Attorney Sagayo, sir, po, no? Mr. Chair, in the history of all of your board meetings, would you ballpark figure how many meetings were those po?
We have a meeting once every quarter.
once every quarter. And that's 4 times a year. And
Correct.
for
Yes, Mr.
more
Chairman.
than a decade. And how many board meetings did you not have a Chinese director present?
As far as I can recall,
Never.
if not all of the board meetings that I attended, everybody was present.
Everybody was
I
present.
just recall one instance when I wasn't, no, I think Abeya. Almost everyone is present. Almost all meetings, everybody's present.
Then that's good to know. So your safeguard was not needed. Because po, Mr. Chair, I believe Section 7 is a safeguard to ensure that at least one Chinese director is present.
It never happened, Mr. Chairman.
No, it never happened because there's a full attendance. So there's always been a Chinese director.
Yes, of
But
course. Yes.
technically, if you want to really cut down, if you really wanted to, if you wanted to have a board meeting of just the 6 Filipino directors, which in normal circumstances would constitute a quorum, you cannot because you need 7 directors. Therefore, one Chinese director must always be present. Is that correct, Mr. Attorney Sagayo?
Yeah. Oh, for on the third. Second, yeah. If we can, yes. There's a, if we do not get the quorum first meeting, we delay, then immediately 7.
Attorney Sagayo, I apologize po, no? I'll just cut you short. I'm not asking about when there's
Okay.
not quorum. I'm just asking, my question is plain and simple. Could you have a board meeting without one Chinese director?
Yes. Yes, it's possible, Mr. Chairman. Assuming in the first meeting there's no quorum, we delay, we adjourn. During the next meeting, 6 is the
Apologies.
majority.
In a regular
Regular.
meeting, the first meeting, you can't. You need 7. It's only in your follow-up, what you call the adjourned meeting, which never happened anyway because you're always present.
Yeah,
But you
that's
have
correct,
that
yes.
safeguard. And in fact, an
Okay.
additional safeguard, Mr. Chair, correct me if I'm wrong, under Section 5 on quorum, paragraph A, in all regular or special meeting of stockholders, 51% of the total issued and outstanding capital stock, which shall at least include SGHK or its duly authorized representative, must be present or represented. You need that one Chinese director in every board meeting. It's in your bylaws, Mr. Chair. So, Mr. Chair, that's what I'm pointing at po, no? Apologies, Attorney Sagayo. Let me finish po na may line of questioning. Earlier, there were already the corporate gymnastics that were employed to avoid public ownership and scrutiny, public ownership, public enjoyment of fruits, public control. And aside from that, as if that was not enough to go through 3 layers of corporate gymnastics, they still have in their bylaws to ensure that there is a Chinese director present. I hope you understand, this is not xenophobia, but we've already gone time and time again about the issues of national security po. And ako personally, this was very alarming. And the most blatant violation of the franchise that I've seen so far. Mr. Chair, I think I'm more than 5 minutes, but I'll leave it at that. I think we still have some issues that, to be clear with them. If I still have time, then I'd like to ask some of our other resource persons, but if my time is up.
2 minutes.
Thank you, Mr. Chair. This will be a little anticlimactic po, no? Kasi I just want to, now that I was able to say my piece, I want to go back siguro po kay Attorney Matibag po, no? And you mentioned earlier that remotely there were instances in which they were able to influence our system grid. Can you please elaborate?
Well, it was reported to us that there was a problem in the power grid and they need a technician to address it. So instead of sending the technician, they relay the problem in China, in Nanjing, so that it will be remotely repaired. But of course, it was not recorded properly and all. But that one instance when it's still Transco is operating, nangyari din po yun, na nasira, pero hindi na po pumunta yung technician, remotely ginawa. So if something that can be done remotely, definitely na i-repair, pwede ring sirain remotely.
Sir, you mentioned po na it was not recorded. There's no history of this incident.
That's the point na nga kasi hindi na nakakapasok ang Transco. In fact, hindi lang nabanggit kanina ni Ms. Dina na yung sinasabing inspection namin doon sa mga documents, hindi nga pwedeng maglabas ng Xerox copy, hindi pwedeng picturean. So, basahin nyo na lang. Can you just imagine voluminous documents na re-reviewin mo? pumunta ka sa lugar na sinabi nila, tingnan mo doon. But before that, Mr. Chair, if I will be allowed, kasi meron lang sinabi si Attorney Sagayo na yung tungkol po dun sa decision ng ERC na copy fairness ang Transco na hindi nag-object, we filed an objection. At ang sabi sa amin ng ERC, wala kaming karapatan na sumali doon sa usapin na yun. The legal officers of Transco are here and that can be validated, Mr. Chair.
Thank you, former President Matibag. On another point, you mentioned yung 777, quite media soundbite po, no? Can you please explain to us po? At least I'm more interested in violations of the concession agreement. Could you please enlighten us, sir?
Well, this report was submitted, ito yung last hearing namin po sa Senado na noong February 3, 2020. So pinag-submit kami ng report, ng paper. So we titled it 777, 7 power grid security issues, 7 reasons why NGCP contract with government is onerous, and 7 NGCP violation of the concession agreement. So, if interested po kayo, Mr. Chair, sa violation, basahin ko na lang po isa-isa para mas madali po. Failure to comply with its initial public offering, yung pong sinasabi ninyo, yung obligation nila doon sa public offering, because our point of view at that time, very clear naman po yung wordings ng Section 8 ng franchise law, dispersal. Pag sinabi mo dispersal, you let go of it, papuntang public, hindi from one packet, punta lang sa kabilang packet. So yun po yung isa. Pangalawa po is violation of anti-dummy law. It's already been established na yung CTO noon is a Chinese national. And I hope na sabi, bibigay lahat sa inyo yung mga papel na nagsabi na sila ay pwedeng mag-empleyado. Kasi alam ko po, madami ng hearing na nangyari sa Senado at sinabing pinangako, wala pa pong lumalabas na kopya. Kaya medyo kanina, pasensya na po ulit, nakapagsalita ako ng lokohan because that's how I feel, exasperated na. 5 taon po naming nilalaban to. Ganun na nangyari. So violation of anti-dummy law, number 2. Number 3 is engaging in business without prior consent because under the concession agreement, any business na hindi po transmission of high voltage electricity, na yun lang po yung binigay sa kanila talaga, ay dapat ipaalam po sa PISAM, sa Transco, ay meron po silang mga nilagay na facilities doon na telecommunication, meaning they're already been engaging in telecommunication. Tapos number 4 po, non-compliance on separated audit accounts. Tapos abuse of improper exercise of power of eminent domain, yung SSS po na expropriation. Tsaka yung pong paglalagay ng mga in-expropriate na property sa pangalan nila, hindi po sa Transco. Yun po yung pang-anim, yung titling. Tapos yung pong receivable ng Transco noon, meron pong receivable na malaking halaga. Baling nangyari po kasi, nung nag-assume sila noong 2009, may mga collectibles pa. Na nung nabayaran nung sila na nandoon, hindi na binigay sa gobyerno. Yun po.
Thank you, sir. That's quite a lot. Although I'm sure that some of them were contentious. I understand some of the arguments earlier was that it was well within the rights of the concession agreement. But I'm curious po, no, in relation to that. Thank you, sir. If I still have time, let's go to one follow-up question kay ERC Chair, Di Malanta. To the Honorable Chairman, you mentioned po earlier that in relation to the delays of the projects of the NGCP, sometimes the project proposal, including the timeline, would actually come from them rin po, no? And they fail to follow their own timeline. That would
Yes.
usually be the instance po,
Mr.
no?
Chair, opo, in all instances po,
All
timeline
instances.
nanggagaling po sa kanila. Kasama po yun sa application po nila.
And I find that interesting because I agree with my good colleague, the gentleman from CDO, my idol chairman, Rufus Rodriguez, and when he mentioned, at least in the ERC, understandably, when there's fault, when you're empowered by the law to take responsibility, you ensure that it happens. But likewise, ganun rin po yung nangyari sa NGCP. If I'm not mistaken, NGCP in their concession agreement was granted in Section 5.6, for example, documented property rights. They have the power to commence and pursue eminent domain proceedings for the purpose of acquiring documented property rights. They have the power to litigate, negotiate, settle, and otherwise resolve all adverse claims in accordance with Sections 5.7. And in 5.7 adverse claims, in the event that any person shall assert any right, title, or interest, some lines down, the concessionaire shall, at its own cost and expense, assert and otherwise defend the documented property rights as promptly as practicable. So all of this are, NGCP was armed to the teeth to proactively address. They had the sufficient authority to deal with this. And in fact, sila nga po yung nagbigay ng project proposal. Yet, in all instances, they failed to follow their own timelines po, no?
In most, hindi naman po sa lahat.
Most,
in most
if I was-
lang po. And their authority to expropriate is also in their franchise, Mr. Chair.
Also in the franchise. So even then, in the same way that ERC was empowered to investigate, but for reasons known to them, they did not, NGCP also had the power to make sure that their timelines are kept, yet they did not. So that, together with the concession violations mentioned by former President Matibag, really raises questions po, no? And siguro po, for now, I want to hear more of Chairman Dan Fernandez's expose on the facts. Just one more thing po, I just like to go back po, no? Have we found yung public ownership po?
The Mr. Chairman, before we go to this, may I just comment on the public dispersal of ownership? Just one comment on that. Kasi sa akin lang po kasi, Mr. Chairman, the provisions of our franchise is very clear. We were given those two options, IPO at NGCP level or a publicly listed company listed with the PSE, which directly or indirectly owns 30% of NGCP. The right to choose was given to us by the law itself. Ang sa akin lang po, Mr. Chairman, sana hindi kami sisihin if we opted to, or kung ang pinili namin ay yung second option.
Okay.
Thank you, Mr. Chair.
Thank you. So can we go back to the question?
Yes, Mr. Chair, for
Thank you very
all
much. We take note
intents...
of that.
sorry.
Yes, go ahead, please.
Thank you, Mr. Chair. Yes, I understand that. And exactly as I said, let's assume colorably you are able to comply with the legal requirements. But at the end of the day, how much is owned by the public?
Mr. Chairman, I will let the Corporate Secretary of SGP answer the question.
If we are referring to only the common shares, it's 8.9%. But if we include all the ownership, because we also count common and preferred shares, it's 10.12%. Public's indirect ownership in NGCP.
Mr. Chair, I believe that is a far cry from the 20% required. And I don't even want to consider, that's even considering the preferred shares, which have no voting rights and would fail. They might, actually, yung first part po ng economic fruits, wala nga yung, it has no priority over dividends. So just talking about yung ownership, common shares, it fails miserably. And I think that's what we are tasked to get through today po, no? At the end of the day, we have to go back to the Constitution. And basically, in Article 12, Section 11, there's a prohibition of the grant except under condition that the franchisee shall be subject to amendment, alteration, repeal, when the common good so requires. And as far as we have seen, Mr. Chair, the common good has not been served. Thank you very much, Mr. Chair.